Hey, did you read that fine law article that was provided to you?
I did, and I asked a member of my household to get a frame like the Declaration of Independence so that it could be prominently placed within my
That's what everybody's doing.
residential dwelling.
That's what everybody's
So
doing.
when I wake up in the morning to put a suit on, to come to a court of law,
You're presuming the right thing.
presumption of innocence.
You didn't disagree, I don't think, with any of that.
It's my new motto, Your Honor, for life.
Little historical stuff there.
It's very, yeah, I mean,
I wrote one on Beyond a Reasonable Doubt that was published in the Judges, uh,
context or viewpoint.
the Judges they have a annual, a monthly, or it's quarterly issue of law articles and things like that. And that was a few years ago, and that turned out pretty good. It was interesting that the
We'll just hopefully they won't pull the cork out, Judge.
everybody ready? Please bring the jury in. Thank you. The record shall now show that the jury is seated in the courtroom. All parties are present. Good morning to all of you, ladies and gentlemen.
Boy.
And we are now recalling clause number 22-39014, the state of Texas versus Stephon Rayvon Angel, who was present with his attorney and the state's attorneys. When we rested yesterday, the parties had announced they rested their cases. Do the parties request reopening for any reason at this time? Stay.
Judge, I don't, but I do believe I need to tell the court that I don't intend to present any state's rebuttal. So we affirmatively rest.
All right, defense.
We have rested, Your Honor.
All right, ladies and gentlemen, the parties have rested their cases. The evidence is before you, and at this time, I'm going to read to you the jury charge, which contains all of the law necessary for your deliberations in this case. In continuing to discharge your responsibilities as jurors, you must continue to observe all the instructions the court has given to you. These instructions are given to you, and they're very important because your conduct is subject to review the same as that of the witnesses, parties, attorneys, and myself. Please listen carefully, as I know you will, as I read this charge to you. The original here will be left with the jury to refer to as necessary during your deliberations. Members of the jury, the defendant stands charged by indictment with the offense of murder, alleged to have been committed in Jefferson County, Texas, on or about December 27th, 2021. The defendant has entered a plea of not guilty to this indictment. Our law requires that I submit the following charge to you in this case. This charge contains all of the law necessary to enable you to reach a verdict. If any evidence was presented to raise an issue, the law on that issue must be provided. Definitions. So that you can better understand some of the words and the terms used in the charge, the law provides the following definitions. Murder. A person commits the offense of murder if he intentionally or knowingly causes the death of an individual. Intentionally. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. Knowingly. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Deadly weapon. Deadly weapon means one, a firearm, or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury. Or two, anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Firearm. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using energy generated by an explosion or burning substance, or any device readily convertible to that use. Bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death. Serious permanent disfigurement or protracted loss or impairment of the function of any bodily member or organ. Prior conviction affecting credibility. In this case, evidence has been introduced that one or more witnesses who testified may have previously been convicted of criminal offenses. The law permits this evidence to be introduced only for the purpose of aiding you, if it does, for determination and passing upon the credibility of the witnesses, and you cannot consider this evidence for any other purpose. Defendant's election not to testify. Our law provides that a defendant may testify in his own behalf if he elects to do so. And this is a right given to a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer to or allude to that fact throughout your deliberations, or take it into consideration for any purpose whatsoever. Charge. Now, if you believe from the evidence beyond a reasonable doubt that in Jefferson County, Texas, on or about December 27th, 2021, the defendant, Stephon Rayvon Angel, did then and there intentionally or knowingly cause the death of an individual, namely Jacoby Jawan Rubin, hereafter styled the complainant, by shooting complainant with a deadly weapon, to wit, a firearm, you shall find the defendant guilty of the offense of murder. Unless you so find, or if you have a reasonable doubt thereof, you shall find the defendant not guilty. Stand by. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense or offenses is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial, and the law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt, after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. You have a right to consider all of the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are in the case. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. And you must not consider facts that have not been introduced into evidence or legal principles not contained in this charge. It is improper for any juror to discuss or consider anything which they know or have learned outside of the testimony presented to you and the law contained in this charge. If a juror should discover that they have any outside information, they must not mention this information to any other juror, nor consider it themselves in arriving at a verdict. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. And you must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in his presence. If any question about the law develops during your deliberation, it must be reduced to writing and signed by your foreperson and then given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Any physical exhibits that have been admitted into evidence will be furnished to you upon your request by the bailiff. After the attorneys present their arguments to you, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during your evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict or verdicts attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case in accordance with the law and the evidence. And we have two verdict forms, ladies and gentlemen. One, we, the jury, find the defendant guilty of the offense of murder as charged in the indictment, a place for the foreperson to sign. And the other, we, the jury, find the defendant not guilty of the offense of murder as charged in the indictment, a place for the foreperson to sign. Under the
Motion for a second. You can say that. This one has 21 on it, Judge. The other one had 2010.
Thanks. All right. Under the rules, the state of Texas may open and close final arguments. What says the state?
You're open. Good morning. Thank you all for your patience this week. I specifically want to thank you for giving me some extra time Tuesday afternoon. I had two particular witnesses that could not be here Wednesday, and I know I imposed on you all. I didn't have the chance to say that, but I'm going to say it now. Thank you. I don't normally give an opening statement. I usually reserve all my comments till the end. But I think with this particular case, I want to get you guys focused in on your job. And I know you're ready to do your job.
Hold on for just a second. I'm sorry.
Yes, sir.
Let me see the long stuff here.
In talking to you all that you'll get a chance to grade my paper, right? And I told you that murder cases by their elements are pretty simple cases to try. I said we get involved in a lot of other stuff. Well, you all have been experiencing that this week. But the bottom line is these are the elements. This is what I have to prove. It's the only thing I have to prove. And I'm up here talking to you first to make sure you're directed to that. Because we've heard a lot of evidence this week that doesn't necessarily go to these elements. Right? So mentally ask yourself now as you're reading that, whether or not I've proven each of these elements to you beyond a reasonable doubt. Did I prove that that's the defendant, Stephon Rayvon Angel? Did I prove that on or about December 27th, 2021, that something occurred here in Jefferson County, Texas, that amounted to intentionally and knowingly causing the death of Jacoby Jawan Rubin? And did that occur by shooting him with a firearm? Once all those elements really were uncontested. There was no disagreement that Jacoby died that day, that he died by being shot with a firearm right here in Jefferson County, Texas on that day. We heard a ton of evidence about what Charles Nicholas did. We don't see his name up there. We heard a ton of evidence about what all these other people did and who all got there. And That's just getting to what, one of the witnesses actually said, we can get into the weeds. That was the doctor that said that. It's a lot of what we did this week. But the bottom line is, ask yourself this. Is there anything that suggests anything other than proof of those elements beyond a reasonable doubt?
I'm sorry, I'm gonna have to change. You're referring to that, and that's
Thank you, Judge.
incorrect.
My judge is really great about this, and y'all probably already know where he's heading.
Yeah.
It's that word and
The statute provides that the state of Texas can charge in the conjunctive and intentionally and knowingly. But the statute reads by the legislature intentionally or knowing. So the disjunctive is what you must consider. They're allowed to, and it's been a historical practice to include the conjunctive usage in the indictment, but the jury needs to understand and instruct intentionally or knowingly can be proven in the disjunctive, either one or both, or what the test will be in a murder charge. Does everybody understand? Okay, thank you.
almost
Hate to make it confusing, and I'd like yours to cut through some of this confusion. Thank you for bearing with us.
thank you, Judge. Eventually, I'm going to correct that slide. Correct. All right. So I'm going to say, anticipating what I'm going to tell you, I pulled out the sheet that defines knowingly. I'm going to read it to you. I don't know who's going to end up being the foreman, but I'm asking whoever the foreman is, pull this out when you get started and read it. Again, I'm going to read it to you one more time because I believe this is the proof that's just substantially right there staring us all square in the eye. A person acts knowingly or with knowledge with respect to result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Example, if I pick up a gun and I pull a trigger, I can reasonably expect it's going to hit somebody and can cause their death. That's what knowingly means. And that's what happened. Now let's hear if the defense can refute that.
That police court.
Yes, sir.
Thank you for the introduction. I again will, as Mr. Ham did, thank you very much, ladies and gentlemen, and thank you for your time. When we started this Monday afternoon in voir dire, there were a couple of things that you told me that y'all were gonna do, and I'm gonna hold you to it. One is that you were gonna listen to all the evidence and take in all the testimony, and not all the evidence, and listen to the testimony. And then take the jury charge, which was just read to you, follow the law, go back there and make a decision. And I'm gonna hold you to it. And I want you to. If it was, can I have the overhead, please, so I don't ruin your, thank you. If it was that easy just to say, here are the elements, and that's it, we wouldn't be up here standing arguing. But it's not. And I would submit to you, and I don't think there's an attorney around that would disagree, never know. But a case is made up of totality of facts and circumstances. So the question comes down, because we have video, the question comes down to whether or not Stephon, I'm sorry, shot and killed Mr. Rubin. What's going to come down to? And if you agree with that, whether or not he intentionally or knowingly did that act. And that has to be in such a convincing fashion or level that is proven beyond a reasonable doubt. And you took an oath for that, because this is extremely important. There are no parties that have won here. You have a dead person and you have an individual that could spend the rest of his life in the penitentiary. And what I say and what Mr. Ham says is not evidence. It only is what I think are important points. And I would believe that's what he's going to say too, saying, look, jury, over this week, this is what we saw. This is what we heard. This is what we observed. And this is where I think is relevant in reference to this. The other thing I want to talk to you about is that one, all these individuals grew up together. They weren't strangers. They had disagreements. They lived maybe a different culture, but that's just the way they were brought up, right or wrong. Okay? They weren't probably brought up with white sheets and on their bed and meals at 6 o'clock in the evening and things like that. They lived down the streets. So we know, starting off, what we heard is there was a disagreement. Now, who started it and what it was all about? It was on Instagram. But how were they going to settle that disagreement? And how they were going to settle it was with a fist fight. Now, rest assured, there are probably a lot of individuals in this area that carry guns that probably shouldn't, but that's just a fact of life. Okay? They do, and they shouldn't, but it's there. And it goes to that culture in which they're brought up in, right or wrong. So what do? Because they know each other. We're going to meet at Gillum Circle. We're going to fight. So they all get in their cars and they want to see a fist fight. They realize they can't do it there because it's public, private, police are there or not there or may show up. They decide, let's go back to where we grew up, which was 11th and Liberty. And let's go fight. You've seen the video how many times? You know. And so they all come and they all get in their cars and they show up. You see anybody with a gun at that time? Do you see anybody get out with a gun at that time? Well, you have some evidence that maybe somebody that testified had a gun, and he admitted he had a gun. But for the most part, no one did. The fight was on. And as you see in the back of the video, Stephon and Jacoby start fighting. And what you hear in the testimony is that Stephon probably got the better of Jacoby. And that probably would account for when the pathologist said that Jacoby had some bruisings in the mouth, in the eye, probably the scrapes on the roadway. Some of them probably were from the fight. Okay. And the fight was over. But it wasn't. Because what you have is an intervening force. And that's Charles Nichols, the half-brother of Jacoby. And what did he do and what did he tell you? Well, he thought that Stephon was going to go or coming towards him. When I would submit to you of what I heard from Mr. Nichols was, this all started with me. There were some words said on Instagram. It's really started with me, and I don't know why Jacoby got into the fight on this. But knowing that, and even with Mr. Nichols saying, Charles Nichols saying, got the better of him, what did he do? They knew I had a gun. I took it out. Now, if you want to believe that he just bladed it or kept it by his side, we provided people that were there, and you got to judge the credibility, but they were there, that said, who pointed it at Stephon? I ain't fighting. Oh no, I got a gun. Doesn't that make sense? Reason and common sense, because that's what we asked you to do. And you know why that probably makes sense? Is because when you see in the video, they're not running to move their cars for the garbage truck. They're moving it because everyone around there knows what's going to happen next. Someone's pulled out a gun, pointed a gun.
didn't keep it in his pocket, didn't keep it down here. I ain't gonna fight like that, or I'm not fighting. So what does everybody do? It's in the video. They run. They run. You see Stephon. He runs back to the car. You see him get a gun. Right? It's in the video. But when he walked back from the car, did you see him pointing it up at anywhere? Did you see him going after Jacoby or Charles? Well, he walked towards there and got to the front of Charles' car, the red one, and stops. He didn't raise the gun up then to say, I mean, I got a clear shot now. I got both of y'all. You want to play with the gun? I'm going to do it now. What does he do? He walks around the car and he goes back to the rear tire and shoots it. Bang. Now, everyone's standing around. Everyone starts running like, whoa, wait a minute, what's going on? But what are you seeing then in the video? You see Stephon, after he shoots the car, walks back to his car. He wasn't running. He wasn't looking around. He was gone. He went back to his car. There were no other shots at that point. Something happened that I've submitted to you that when he got to his car, that's the reason why he turned around, raised his gun, and shot. Now, what could that be? Using your reason and common sense and what you heard from the stand here. I submit to you that once the shot happened, Charles started or was going to start shooting because everyone heard the shot. Because what did we hear? Even from Charles, my brothers came towards me and tried to get the gun away from me. If he wasn't in a threatening manner, if he wasn't about to use the gun, why would they ever want to take the gun away from him? Why? You heard it from Charles. You heard it from one of the witnesses that I produced, Mr. Thomas. Why then, if he was not threatened, they wanted to take it away? Because he left. He was getting back in his car. But I submit to you that in the struggle, that Charles started to shoot. He started to shoot. That's when he stopped and said, oh, they're shooting at me. I'm going to start shooting back. And it's during that struggle, I'll submit to you that probably Jacoby got shot. Now you're going to say, how did I figure that one out? You don't see the struggle in the video. You heard Charles. Both of them came up. You didn't see that in there. But one of the things, and you remember my questioning to the pathologist, the bullet wound on Jacoby. Where did it go in? Went in the right side. Where did it come out? Came out his neck. Would you agree with me? 45-degree angle? Yep. Give or take a couple of degrees? Absolutely. So when you look at that, and you look at the time that Stephon shoots, you also have to take a look at that video to find out what's in his way and how he shot. There were 3 cars in his way, or 2 cars in his way, all right, because you know they were behind or in front of the white Tahoe. There were bushes and trees, and he was across the street in the intersection, pointing straight. We know that Jacoby is 5'8", maybe. That's what's on the autopsy report. 5'8". And we know that the bullet came in, had to be somewhere around a 45-degree angle coming up. Remember I asked the detective? Because he went through, if I hit something at, 2 miles or whatever it is. You expect that whatever this distance was, it would be accurate. Yep, would be some deviation, but had to be accurate. Proof beyond a reasonable doubt. We know that the other shots that happened then, in reference to Charles, he starts shooting. He's in the middle of the street. He's in front of he's in front of the white car, and this is State's Exhibit number 5. He's in front of the white car. He's over on this side. We know there's a ditch here where everything is in reference to the shots. Let me add something else. You've heard evidence, and they've made a big deal in reference to presenting evidence from witnesses. This is Charles' weapon. This is Charles' clip magazine. Capacity is 17 rounds. One in the chamber makes 18. There was one left in the chamber. So that means 16, one in the chamber, 17. They recovered 12. Where are the other ones? I submit to you because I asked the detective, and the reason why I asked for him, in the pictures, you see detectives that are combing through the grass. I asked whether or not they used a metal detector to make sure they got all of the casings. And he said no. I submit to you that Charles probably might have had that gun at capacity. They just never found the other shells because they were either kicked, run over, because we knew there were 4 or 5 of them that had been run over because of the crimping, or they were still out there in the grass. Remember, I went over that, reference to the different colors and stuff like that. Proof beyond a reasonable doubt. The other thing I want to bring up, ladies and gentlemen, is that during this video, and you're going to see a lot of this video in about a couple minutes, not from me, but a lot of this, at the end, you see the white Tahoe that we know is Chan Rubens. There was some type of testimony that says he was rushing to the hospital. That was what the excuse will be, or what the reasoning is of why he had to get out of there so fast. Play the whole video, because at the time he sped off and didn't want to get stopped and didn't want to be there before the cops, his brother was still laying on Thomas Boulevard dying. You know that because the officer that chased him down 11th Street had to call it off and went back to Thomas Boulevard and gave aid to his brother on the side of the road as Jalen Thomas held him, saying, please help him. So he wasn't trying to get to the hospital. He was going there for some reason or to hide something, I would submit to you. Or he took something away from the scene. Why would you leave your brother dying on the side of Thomas Boulevard? If you take the totality of the circumstances, ladies and gentlemen, everything, I ask you to take a look at everything and consider everything to the point of beyond a reasonable doubt. There is doubt. And I'll leave you with this one thing. During this week, the state made an exceptional effort to tell you and made the witnesses say, look at that video and look at that time. And when they said the time, no, I want you to go to the second. Remember that number of times? 12:52, 12:53 in some seconds. If you want to take that as correct, Please go to State's Exhibit number 50, the hospital video. Because when Mr. Commander was up there, do you know what time was on that video? 12:50. And he said that was accurate. So which one was accurate when you're gonna either a home video thing or a hospital, or do we really know whether or not those times are accurate or not? And here it says 12:50 in front of the hospital. For Mr. Commander. So when you look at that in a minute, and he's gonna go and split the screen and everything else. I guess they were at the hospital before it happened. Well, that's what this video says, the time. Well, who knows what the time is? And that's State's Exhibit 50. Bottom line to this, ladies and gentlemen, it's a terrible thing. That's what has happened. Someone has died. They were friends or at least acquaintances. They all acted alone and they thought they were just going to settle a fight, as usually a lot of people do in reference to a fist fight, and everybody goes home and they come back another day. We know that Charles was out of control because he's testified that his adrenaline was such that he doesn't remember what he said or what he did and couldn't remember. You can remember his testimony right there, and you can ask for the judge to get it back to you. And during that moment, when his two brothers tried to wrestle the gun against from him, I submit to you that it was when he shot the tire out of the car that Charles became incensed of what he was doing and started shooting. And during that time, either it hit the ground or the way it was, that's the only person that could have hit Jacoby. Just by the angle itself, 45 degrees coming up. On the very last page, one of the before the verdict form, ladies and gentlemen, there's an instruction. And I always thought it's most important, and everyone's heard it if you do this long enough, and I've been doing it since 1990. It says in paragraph 8, in returning your verdict or verdicts, it is your responsibility to make certain that justice is done in this case in accordance with the law and the evidence, and you're going to receive it. I asked you Monday whether or not anybody would have a problem doing the right thing if they did not prove beyond a reasonable doubt the elements. And you all said that you would. This is what we asked you to do. Good, bad, guilty or not guilty. Make a decision because we couldn't. And I trust that you all will. Thank you again for your time. This is the last time I get to talk to you. If I forgot about something or I didn't explain something to you and it's shown after Mr. Ham now gets up, why didn't we hear this or hear that? Blame me. I'm Stephon's attorney and his freedom's in my hand. Thank you.
State of Texas, please.
I shared with you all that I don't normally give an opening. I'm glad I did this time because I got to be calm, cool, and reflective. I'm trying to gather myself after hearing that closing argument. So in gathering myself, best way to do that is for me not to get emotional about it and lean in on what the judge tells you in his charge. Okay? It doesn't matter what Tom says, doesn't matter what I say. Mr. Burbank and I are attorneys. Our questions and our comments do not constitute testimony and must not be considered as evidence. Evidence comes from this table right here, and what came from that chair. That's the evidence. Next thing. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. In other words, if I say something that's not in the law that the judge gave you, I say some obscure thing, and you go, gosh, you can't go along with that. Same thing is true for him. I challenged the defense when they got up here to give you any reason to believe that the elements were not proven beyond a reasonable doubt. It was real clear what I said as I sat down. The suggestion from defense counsel was that in these courtrooms, it's not about the elements. That you have to consider the totality of the circumstances is what his words were. On this big screen, I've got the court's law to you. Not what I say, this is what the judge says. The prosecution has the burden of proving the defendant guilty, and it must do so. And he tells me how. By proving each and every element of the offense charged beyond a reasonable doubt. And if I fail, you must acquit the defendant. You must. If I don't do my job, if I don't pass that, we grade my papers. If I fail, I expect you to acquit him. Nothing in this charge says that you're supposed to look at all the totality of the circumstances in making that decision. Yes, you consider the evidence, but the judge gives you the parameters. You do it by looking, is there proof about the elements of the offense? I submit to you it's overwhelming. We talked on Monday about some of the ways in which that can be shifted, and we talked about self-defense. Remember? We talked about if somebody kills somebody, is it justified? You would have gotten a whole set of instructions about that if there was any kind of evidence that raised that. There's no instructions about self-defense because this killing is not justified. The suggestion that you consider the totality of the circumstances goes back to this instruction from the court. You must disregard any statement of the attorneys that is inconsistent with the law contained in the charge. His suggestion to you is that Charles Nicholas, and let's get his name right, it's Nicholas, Nicholas, that his conduct is the cause of this. He's not on trial. Chan Rubin is not on trial. Stephon Angel shot and killed Jacoby Rubin. Nobody else. Why on earth would we shift the blame to somebody who's not charged? This is what gets me so upset. But I'm leaning in on this instruction. I don't fault Mr. Burbank. I've sat in that chair for years, as I've talked with you all about. And it is difficult when the evidence is overwhelming. It is difficult when you can't get someone to accept responsibility and stand in front of somebody and move forward. But I will never fault a defendant for asking me to come in here in the courtroom and to do my job and to prove that case beyond a reasonable doubt to you. That's why we're here. So let's deal with the last little curveball that is thrown. It is suggested that you look at this hospital video and the time mark is up there and whether or not those things are accurate. I think you guys have paid enough attention. By the way, I'm not showing the videos. You've seen them enough. But for my note takers, I'll remind you about some of the times. And again, I saw y'all taking notes, and I really 100% appreciate all the attention you've given this. The time's important because I'm synchronizing the two videos. The time's important because of what we're looking at. And again, it's all the conduct of this man right here. At 1:52:19, the time demarked on these videos is when he shoots the tire. Detective Cousins does a great job of telling you when he's reviewing all that, he's watching the people. And we watched them, and we watched them, and we watched them. Nobody between these two time frames, here and the next one of 1:52:53, reacted like anybody shot a gun. That is key, because that's the argument that they're making, is that Nicholas shot a gun, and that's why all this happened. Common sense tells you entirely different from that. I went frame by frame, painfully for you multiple times, so that you could see him holding the gun up at 1:52:53, see that puff of smoke, and then at 1:52:54, see Mr. Rubin fall down. We got into a whole discussion about, was there any blood there? Well, of course there is. That's why I brought you the video to show you that. Matches the blood trail, and then he goes all the way over there and he dies. So big thing when we deal with the doctor about the direction of he gets shot under here and it comes out here. I don't know how he was standing. He could have been standing like this. He probably wasn't facing the man that shot and killed him, but he was forcefully thrown to the ground and had to try to get away. What on earth did Jacoby Rubin do to die? Not a thing. Not a thing. These times here was when the defense suggested that we look at all that. That is when there's obviously some shooting going back and forth after this man shot. They suggest that they're running there. They even played the Where's Waldo game with all the other folks. You help me shit to my PowerPoint. It's no wonder I lose sleep at night. Can't get past my own notes here about who really is on trial here. Those elements. Get back on track. That man right there, on that day, in this county, your county, knowing caused the death of Jacoby Rubin by shooting him with a firearm, which we don't have. I pause like that because the other guy that keep fussing about, he freely gave his gun. Now we're supposed to speculate whether or not it was full or not of its bullets. Come on. Come on. Every bullet that came from this match is a quantity. Just like a lawful gun owner would have. A gun, all the matching bullets, good to go. That whole 9mm, that's gang thug type activity. That's the truth, y'all. I want you to follow the truth. Not all those weeds that we were talking about. All the state's asking you to do is to consider and follow the evidence. Because it all supports the elements. Your common sense is what I want you to use. Again, I've been in Mr. Burbank's chair before. I understand what a daunting task this is. And he has to distract you. He has to confuse you by muddying up the waters, getting you distracted by not pronouncing people's names right, getting all caught up in different little legal issues or factual issues that don't make a difference. But just like Dr. McLean says, we don't really want to get caught up in the weeds. You know, it's that whole explanation he was talking about when he was being questioned about marijuana in Mr. Rubin's system. That had nothing to do with whether or not he died that day. Nothing. Just a form of discrediting. Let's talk about him using drugs. Let's talk bad about his brothers because this man let him die that day. Those are all the witnesses that you've heard. Mr. Angel's up there. Got any question about all that? State's Exhibit 71. He's being interviewed about that wound on his foot. Remember how none of it, not a single word out of this man's mouth matches anything that we've been talking about today. If he was saying, I did all that because they were shooting at me, that's a common sense thing. You all would have said that. If you were laid there in the hospital and somebody pulled out a gun and started shooting at you and you got shot in the foot, you would tell the officers that. And you would tell them that you want him prosecuted. This guy didn't even want his picture taken. Wonder why. Remember that, don't take my picture. Guilty people act like that. Guilty people flee the scene. Guilty people don't give you a gun that they have. I don't have to prove why he did it. I don't have to prove that he premeditated about it. I don't have to prove that I don't have to bring his weapon. I'd love to have it. I'd love to match it to all this stuff, which my reason and common sense tells me in 61 that he shot every one of those. I know that. You all know that. You saw it on the video. I just thought I was gun to prove it 100%. Look, follow the evidence and you apply your common sense. Maybe you'll get as upset as I did. So ultimately, this is supposed to be about justice for one person. The defendant is on trial, and obviously, if I didn't do my job, he should be acquitted. But I think it's really clear. Jacoby's the victim here. It is crystal clear who's responsible for his death. Let's get him found guilty and move on to him.
All right, ladies and gentlemen of the jury. Here's the jury charge. I'm tendering it to the bailiff. I'm going to ask the 12 of you in the jury box to step down from the jury box, follow the bailiff into the deliberation room. The two alternates, by law, only 12 people can be in the jury room. So I'm going to ask you if you'd be so kind to wait close by, hold vigil, and stand by as alternates. Thank you very much. I don't see where there is a formality that needs to be made where he has to plead true or untrue. I know the way we do things on the enhancements on paragraphs that enhance subsequent paragraphs to the primary charge on indictments. But the key is given fair notice and of what the state intends to prove. And at the end of the day, he can stand by the presumption of innocence, and the law states that your burden is to prove it. Even when you plead true, when a plea of true is done, supplemental evidence is made to support the plea. But the defense acknowledges you're on notice. You've been aware of this first amended notice of the state's intent to enhance punishment with a prior felony of assault of a public servant on February 7th, 2017, in cause number 1165 in the 21st District Court of Lee County, Texas, which the state intends to present before the jury and presumably ask for enhancement of punishment if the defendant is found guilty. Punishment can be enhanced to no less than 15, nor more than 99 years confinement in prison or life in prison.
Yes, sir.
And defense acknowledges that notice of those allegations have been received, and you've discussed that with your client. Okay. Is that true, sir? All of this, you're aware that that this prior conviction can possibly be presented before the jury, which would enhance your punishment range.
Yes, sir.
And you've discussed that with your attorney.
Yes, sir.
In the event you're found guilty, it's not guilty, you're walking out of it.
Yes, sir.
Okay.
In theory,
In this area somewhere.
but he's got other pending charges.
Oh, that's right. We've got a couple of other indictments pending. But that would end this case if they're not guilty. All right. We've got a verdict. Let's bring the jury out and receive the verdict. Thank you. And thanks the alternate jurors for holding vigil. Thank you very much. And the record shall now show that the jury is in the courtroom. Mr. Jones,
Yes,
I
sir.
believe you are the jury foreperson.
I am.
And I'm going to ask you a couple of questions. Number one, the court has received a message from the jury that the jury has reached a verdict in this case. Is that so, sir?
Yes, sir.
Is this a unanimous verdict? That is one that is agreed upon by all members of the jury?
It is.
Do any of the jurors disagree with your foreperson's representations? No disagreement. It does appear to indeed be unanimous. If you would be so kind, pass the documents to the bailiff. You may be seated. I will review for proper form and publish the verdict. And the defendant shall rise. In cause number 22-39014, the state of Texas versus Stephon Rayvon Angel, we, the jury, find the defendant guilty of the offense of murder as charged in the indictment signed by the jury foreperson. The verdict is received. It is made a part of the record for all purposes. Ladies and gentlemen of the jury, at this time, I have accepted your verdict finding the defendant guilty of the offense of murder as indicted in this case. And that brings us to a close of phase one of this bifurcated two-part trial. We will now proceed with the punishment phase of this trial. And once again, let me repeat, you are still under the instructions that the court has given to you up to now. Let me see lawyers, please. Thank you. Break for lunch. Can all of you return back? Is 1:30 going to be enough time? It's 1:23 now. That's a little over an hour. Is that good? Okay, thank you. And we'll wait on you. You're coming in from lunch a little tardy. That's all right. Please remember the instructions the court has given to you. We'll see you all back at 1:30. Thank you very much. Everyone else remain seated while the jury exits first. Thank you. You get this right. Can you get one? Oh, okay. Anything to be brought up by the parties at this time, state or defense? We're in recess till 1:30 on this case. David, let's get your stuff done.